the Senate's Legal and Constitutional Legislation Committee. We're going to go to Senator Ludlam, the Australian Federal Police, before us.
Thank you, Chair.
That's okay.
Good afternoon. Hello again. You'd be aware Telstra, thank you, were recently logging all 3G users' web access over their mobile network, and we're sending the information to an overseas server for the development of some kind of new filtering product. And there have been suggestions that this behaviour from Telstra was in breach of the TIA Act and warranted investigation by the Federal Police. So can you just fill us in? Firstly, are you aware of the breach that I'm referring to?
Yeah, Senator, I'll just get the head of our high-tech crime unit to come up to the table and perhaps give you some more detail.
Assistant Commissioner Neil Gagan, National Manager of High-Tech Crime Operations. Senator, that's the first I've heard of that, and I'm in regular contact with Telstra.
Oh, true. Okay. That is the. Are you? So, can you just tell us? Is it the first you've heard that the AFP's intervention was called for, or the first you've heard of that data breach?
First I've heard of the data breach.
Oh, that's interesting. Well, it might help if I table some material for you so that you know what I'm referring to, because I'm aware that a number of people did make complaints, and it was effectively transferring traffic on Telstra's network to a cloud hosting provider in the United States, which then potentially exposed Australian data to the Patriot Act, which obviously has very different ideas around privacy protection than we do here. And a number of constituents that I'm aware of did receive traffic back from the AFP saying, we have to prioritise, our caseload is very heavy, we won't be investigating this one. But if you're not aware of that, I might come back to that later and give you some material to work with. To whoever wants to take these questions, just referring to the National Security Inquiry that's underway at the moment, it's before the Joint Committee. Has the AFP, I'm aware you gave evidence sometime, you gave evidence on the 26th of September with a number of other commissioners from around the country.
Yes, I did, Senator.
Has the AFP also given in-camera evidence to the Joint Committee?
Yes, it has. In fact, Assistant Commissioner Gagan and Deputy Commissioner Phelan appeared before my appearance. I haven't got quite the date on that.
It was about 7 days before, Senator.
Okay. If you can provide us on notice with the date.
Yes, well, we certainly could have a look now and get back to you very shortly about that, good. But it was a few days before that my appearance.
All right, great, thank you. I've got quite a keen interest in this one. Can you just tell us the AFP's role? So you're giving evidence to the Joint Committee now, which is good. Can you tell us about the AFP's role in the lead up to the announcement of this committee? Did you play some part in forming the terms of reference or provide material for the discussion paper that came with the committee?
Yes, certainly, Senator. We've been involved from the outset in relation to this particular issue, working with the Attorney General's Department and other Commonwealth agencies in relation to preparing the discussion paper that was put forward before the committee. Obviously, as a user of the Telecommunications Interception Act, we have a strong interest in where this goes. There has been a number of different meetings convened over the period of time before this paper went forward. There's working group level where the people are talking about exactly the content of the proposed bill, and there's also more senior discussions in relation to some of the strategic issues that are currently before that committee.
All right, thank you. Now, I'm aware that this, at least from the Attorney General's Department's point of view, goes back a number of years for meetings that they had convened with telecommunications providers. Were the Federal Police involved in those meetings?
Some of those meetings, Senator, I've certainly been involved in, but and that's been with some of the larger telcos, particularly Optus, Telstra, Vodafone, Hutchison in South Australia. Some of those meetings I have been involved in and others I haven't. That question's probably best answered by the department.
Yep. Well, no, as for the Federal Police's involvement, they'd refer me back to you. Are those meetings ongoing, or have they lapsed while the Joint Committee does its work?
I had not been involved in a meeting of that nature for at least 6 months.
Okay. Does that mean they're not occurring, or your involvement has ceased?
Well, my involvement's not occurring. Whether they're still happening would be a matter for the department. That would be a matter for the department.
The department. All right. Thanks. So you recently sent Deputy Commissioner Phelan, is it? Phelan, thanks.
Senator, yep.
Around the country. I'm just going to cite briefly from the evidence that you gave a week or so ago. You sent the Deputy Commissioner, in quotes, around the country, and he spoke to every jurisdiction about the issues we saw as being important for Australian law enforcement. Why have you done that? Why has the Deputy Commissioner been tasked to do that?
Senator, because it was a federal committee, we basically saw that somebody needed to take a bit of a leadership role from the law enforcement perspective, and it's one of the reasons I asked my fellow commissioners to appear together so that we could have a bit of a united front, if you like, and put forward those issues from the law enforcement perspective. So because, as I said, many of the states and territories do use interception and are involved in this process but don't really have a voice other than providing a submission to the committee, we sent Deputy Commissioner Phelan around to just talk to them about issues that we thought were important, seek them and encourage them to actually put a submission into the committee, which most of them did, and answer any questions they may have about how this process is undertaken at a federal level.
All right, and that evidence, or some of it at least, is now on the public record.
Senator, and I have to say too that we put a public submission to the committee, and again that's available on the website, and our position is very clear in regards to what we were trying to do here. The information that was provided in camera by Deputy Commissioner Phelan and Assistant Commissioner Gagan was very much about the operational examples of these issues around methodology. So there was nothing untoward in that regard. It was more things we wouldn't put on the public record because of our operational capability.
Yeah, I understand that. So that material will also be on the reach of this committee while we're in public session. I'm just interested, I suppose, in the idea that you would send a Deputy Commissioner around the country to get everybody onto the same page before you gave evidence.
Yeah, Senator, look, can I just say that I see this as one of the most important strategic issues for law enforcement in the next decade. I mean, if we don't get this right, balancing the privacy obligations and the privacy principles that underpin the TI Act in 1979, then from a law enforcement perspective, the Australian public are going to have an outcome which is going to be suboptimal, and that is that organised crime and terrorists and other things will get an advantage which I don't think had been anticipated in this regard. So we're not seeking additional powers. All we want to do is modernise the TI Act to the context of what is really the communications and telecommunications industry of today. And in 1979, when this Act was launched, I don't think anyone could have foreseen what this would become in the way that people would communicate in 2012 and beyond. So we want something that's technology neutral. We want to protect people's rights and liberties. We don't want additional powers. We still want to make sure that people are obliged to go and seek a warrant from a judicial officer to get content data. But for non-content data, they're the things that we've been talking about here, about the fact that a telephone conversation took place, where it took place, what the numbers were. Those are the sort of things we see as really important to get some consistency across telecommunications carriers and other areas for use in law enforcement, quite legitimate use in law enforcement.
Could you provide us with your working definition, written or otherwise, of non-content data?
Absolutely. In fact, I have one written down. So
That's a new one.
this one. Well, yeah, you could tender it. Yeah, well, sorry, Senator, we could actually tender one. The department has one here which we've worked on. So
I'd appreciate that.
We've got a definition here. In fact, Senator, it's probably useful, particularly if you're going to talk to some of the other agencies about the same topic and us. It's actually important that we make that available to you.
I would
on
greatly
behalf
appreciate that.
of the portfolio, really.
With the consent of the chair, that's...
Okay.
And Senator, I agree it'd be useful to table this because there has been a lot of confusion in the media reporting about what is content and non-content data.
Yeah.
And I think it has unfortunately alarmed many people that certainly some things would be looked at by law enforcement when in fact I think that's not exactly the case.
It certainly alarmed me, and we'll go into a bit of detail as to why. Do you think it's appropriate, and I'm just checking, Chair, you're happy for that material to be
That's
tabled
fine.
and circulated? Great. Can I just summarise the sketch without having seen the document that you're about to circulate? That the definition of non-content data is basically anything except the content of the communication itself, or is it a bit more technical than that?
Have a look at the definition first, Senator.
All right, we'll come back to that in a moment then. Do you think it's appropriate, Commissioner, that that material is at the moment being applied for by a range of, I don't know, you could bit under 24 agencies, I guess, as the TIA Act annual report describes, without warrants at all? And you've actually provided us with the paperwork that the AFP is obliged to go through to obtain those. But you acknowledge that no warrants are required.
That's right, and as I think I've said to you before, I think the AFP applied for 23,000 of these last year. So if you were wanting to grind the AFP to a halt, then you should implement a warrant scheme to actually do non-content data applications, because 23,000 of these would require 23,000 judges to consider affidavits for those to be prepared, to those to be granted. It's an unrealistic expectation. I think there are certainly significant safeguards in place, and I'm confident that internally within the Australian Federal Police, we actually provide a level of scrutiny and accountability to that we treat very seriously.
Can you tell me why you think it's appropriate that suspects need to be named and targeted, serious crimes need to be under investigation and warrants need to be applied for a direct intercept of a phone call, but for detailed locational data, moment by moment, of exactly where I am at every given moment of every day, shouldn't necessarily or shouldn't have any warrant or any of those preconditions applied? Why is one worthy of such protection and the other
Well,
not?
one is a far greater intrusion into an individual's personal discussions than the other one of just where they are
Commissioner, I
located.
strongly disagree.
Well, Senator, that's a matter for you, and that's what the committee is actually considering. And I was just going to say at the very beginning of this, this whole information is being considered by another committee, which we've appeared before. We've put a public submission in. We've had a number of our officers appear before. There's been a range of different views expressed, and really it's a matter for that committee to consider all of those and then make recommendations accordingly. We are but one player in this process.
It is.
We have tried to play a coordinating role to look to have the best possible information available to the committee so they can make important decisions. But as I said at the beginning, I don't resolve from it. This is perhaps one of the most important things that law enforcement will face in the next decade, is to get this right, balancing the privacy issues with the availability of data and information to law enforcement to protect the community.
I recognise that and I understand that. It's also a legitimate role of this committee to put precisely the questions that I am while you're flying people around the country trying to get everybody on the same page.
No, well, I reject that, Senator, and this is not about getting people on the same page. This is about coordinating a response. This is about we didn't tell people what to say in their submissions. We just encouraged them to be part of the debate and answered any of their questions about what would be the federal process and about how this would unfold. So I reject your assertion that we sent someone around in an untoward way to get people onto the same page, because that's not what was actually undertaken.
Do you concede that, and I've got the definition that we're working to now, so I appreciate that. Do you concede that, and it's not just the federal police applying for these, it's the tax office, it's at least one local government authority that I'm aware of, welfare agencies, anti-corruption agencies, all sorts of folk. Do you concede that you are now able to create very, very detailed real-time maps of individuals' social networks, their movements, their transactions, effectively everything about their lives apart from the content of the communications?
Senator, you'll note that that document you have in front of you does not talk about web browsing. So we're not seeking web browsing as part of that.
It relates to communications for
Sorry,
internet.
Senator, it does not include web browsing.
It says internet.
It does not include web browsing.
So I think Mr Wilkins makes a very good point. It's actually a very important, you're talking about getting into the details of what someone is looking at is arguably content.
Yep.
And we're not after content. We are after clearly what's defined in that as metadata. And it's important for us to actually have that information for us to undertake basic investigations. You know, all of the sworn members in this room have been in the police force for in excess of 25 years. I can't recall any investigation that I've been involved in as a constable, or the investigations that I've oversighted as an assistant commissioner, or the ones that my telecommunications interception arm is involved in, that don't use metadata. It is the primary function of law enforcement. The fact that the authorisations nationally, as recorded in the annual report, have been consistent over the last 3 to 4 years, in my view, shows that the use of metadata is efficient and effective in bringing people to justice. Otherwise, we pay for this information, Senator. If it wasn't effective, we wouldn't be using it. We'd be doing something else.
I'm not arguing about its effectiveness. Can you please explain to me how the data that falls into two categories, I'm just going to read from the sheet that you've just tabled. Part 1 says relates to communications for, item 2, internet. And then it says information that allows a communication to occur. The first dot point there says the internet identifier. I'm presuming you mean an IP address there.
Correct.
Assigned to the user by the provider. But you're telling us that would not allow you to identify web traffic.
What it does,
That's
Senator,
right. That's right.
What it does, Senator, is it allows us to identify who's used a particular IP address when they've undertaken a certain activity, for example, downloading child abuse material.
From the web.
From the web. If we don't have that IP address, we can't start the investigations.
No, I'm with you, but I'm also profoundly confused. You've just explained that this is not about identifying web traffic. It's not how I read this piece of paper.
You would need to get a warrant to get that information, Senator.
You would need to get a warrant to find out, for example, a specific URL that someone had visited, not a copy of the page, but the URL.
Well,
That's not my understanding how the system works at the moment.
Well, Senator, for instance, how it works in the child protection investigation is a very good example. We receive from our international law enforcement agencies, we receive what's been accessed, i.e. child abuse material, and an IP address. That's all we get. We don't get any other information. We then utilise, we then ask the telcos to identify who has accessed that IP address for us to enable to commence the investigation.
Yeah, so who held the IP address for a period of time in which content was accessed? Is that
correct? Correct. But it's undertaking our specific investigation. We don't go on fishing expeditions. We don't obtain IP addresses and then go seek the internet of what they're looked at.
But there'd be
But
nothing.
it's web browsing.
There'd be nothing preventing you from. You guys are busy, and presumably you don't have time for fishing
Correct.
expeditions. But there'd be nothing preventing you from doing exactly that.
Well, as
law
Mr. Wilkins said, we need a warrant.
The law prevents them, Senator.
I'm not sure that it does.
It does.
If you can provide us with exactly how that's the case, I'm sorry, that directly contradicts
Well,
what
I
you
guess we'll
provided
just
us
have to
here.
sort of spell it out in words of one syllable for you, but it does.
That's a profoundly unhelpful response to the question. If you want to do that, then you'd be very welcome. I'd like to see you try.
We are trying to be helpful, Senator, but I gather, we've just explained to you how this is meant to operate.
Okay, so of the $250,000, and this will be a bit out of the hands of the AFP, I can put this to the department a bit later if you like, of the just under $250,000 metadata or communications data requests that were reported in the last annual report, none of that relates to web traffic. Because if that was the case, you'd need warrants.
The majority of Catherine Smith, Assistant Secretary Telecommunications Surveillance Law Branch, Attorney General's Department, the majority of those requests actually are in relation to subscriber requests, just name and addresses and things like that. The internet aspect of that will be in relation to IP addresses. An IP address, for example, that through an intercept they have found out that there are various people accessing it, and they'll have these random number of IP addresses. So they'll go to the provider and they'll say who belongs to these IP addresses under a data authorisation. But they have no authority, and the law does not allow them to access the contents of a communication outside a warrant. And the TIA Act is very clear in its definition of what is a communication to include issues like web browsing and anything that goes to the substance of a communication.
Yeah, but I can give you a URL of a web page without disclosing what's on that page. So what I'm trying to identify now, in words of one syllable, is whether a URL is communications data / metadata or whether it's content.
The department has always taken a very conservative approach in relation to URLs to ensure that there is no unintended access to content of communications under data authorisations.
Okay, but you're able to point me to the part of the Act that says it is or isn't a URL?
There is no definition under the current legislation, and as has already been noted, this is a matter for the PJCIS as far as modernising
It's
the
a matter for this
legislation.
committee as well.
Well, also, Senator, what we're saying is that's our interpretation of the current legislation, and it would be made very clear in new legislation that is the case.
Okay, that a URL is, for the purposes of the way that you're currently interpreting these requests, a URL is content,
That's right.
not communications data. That's right?
Correct.
That's right.
Can we go to the working group that you mentioned earlier, Mr. Negus? The working group is there. Maybe if you want to just spell out what its task is at this stage.
I think Assistant Commissioner Gagan mentioned the working group, but I'll pass back to him.
Yes, initially, Senator, it was to discuss some of the things that Ms Smith has actually alluded to, the fact that there's no definition in relation to a lot of the issues that are currently open for discussion and debate, and to try and come up with some terms and some words that everyone agreed to. We've still got some work to do with that, and the committee's actually come back to us a number of times in relation to some of those particular issues.
All right.
The working group was also responsible for assisting in putting together the discussion paper that forms the basis of the PJCIS discussions at the moment.
All right. Is that working? Are you able to provide for us the membership of the working group and what its standing is? Is it informal or does it have some standing?
That's probably best answered by the department. Certainly, the AFP has a member on that group, but it's probably an answer for Ms Smith.
Mr. Wilkins, can you, or whoever
Do you want
wants
us
to
to
take...
answer questions on this? We might as well. We seem to be on them. There is
to
no
it.
working group at the moment, Senator, actually.
There is or there isn't?
No, it's basically in abeyance. I mean, we're basically waiting to see what comes out of the committee, and then we may reconstitute a working group.
There was a working group that was stood up to help produce that discussion paper and the terms of reference, and then it was stood down for the time being.
Is that right?
No. What the working group did was looked at the need to reform the legislation, as Mr Gagan has said, and it was about just coming up with some of the challenges that the current legislation faced. The work on the terms of reference, etc., was done by a different group of people.
All right. Can you provide for us an idea of the working group when it was active, when it was working, the membership and the duration that it worked for?
It was essentially the Attorney General's Department, the AFP, the Department of Communications.
Just who from... you can put this in writing if you'd prefer.
If you'd prefer us to take it on notice.
We'll take it on notice.
We'll take it on notice.
Then
but
we'll make sure that we get the names right.
Yeah.
Yeah, just in terms, well, particularly from the communications from DBCDE, like what officer or at what level they were represented. Privacy Commissioner?
The Privacy Commissioner.
we've certainly consulted the Privacy Commissioner.
Were they on the working group when you were...
I'm not sure. We'll take that matter on notice.
You're not sure? Can't recall if they were involved?
It was some time ago because we've moved into the PJCIS phase now, so I'll have to take that on notice.
All right. I can probably leave it there, but I'm just interested to know, and you've undertaken, I think, to take on notice, who the membership of the working group, where it was headquartered or what its secretariat was, and for how long it worked. I might, I've got a couple other questions on this, but it might make more sense to bring them back to the department a bit later in the evening.